Good afternoon, and welcome to our quick webinar on the new Mental Capacity Assessment template. My name is Victoria Gant, and I am the Mental Capacity Act and Deprivation of Liberty Safeguard Practitioner for the Trust. So the aims for today are for you to be able to understand why we needed to update the template, how to complete the template, and finally, who to contact for support. So why did we need to update the template? Firstly, the Mental Capacity Act is a law, and as cases are brought to the Court of Protection or other courts, they set a precedent on how the law gets interpreted. The Mental Capacity Act has been around since 2005, so there have been a lot of court cases and therefore a lot of changes. The two cases I've highlighted both make recommendations that the way that we approach capacity assessments is wrong, and that as a rule, we should follow the updated guidance that firstly, an assessor should consider the functional element. Can the person understand, retain, weigh up, and use the information and communicate their decision? And then secondly, they should consider if there is an impairment or disturbance in the mind or brain. The previous template we used had been rejected on occasions when it was sent externally, and this was due to the fact that not all of the questions were routinely being answered, as we had the option of failed at previous step. It is important that all 4 questions are answered and detail is provided. The previous template did not include a section on best interests. A review completed last year of the mental capacity assessments within the Trust found that certain elements within our capacity assessments would not routinely being documented, and we have included these in the updated template to ensure that these areas are now considered. So our goal overall is to improve the quality of mental capacity assessments within the hospital. So the first of the new questions is, what actions have you taken to assist the person in making the decision? Under the Mental Capacity Act, one of the 5 principles is that a person is not to be treated as unable to make a decision unless all practicable steps to help them do so have been taken without success. We have to have given the patient the best chance to make the decision by themselves, and we need to evidence this. So I've put down some examples of what we'd expect to see, but perhaps you've ensured they're wearing their hearing aids. Perhaps you've provided an interpreter. Maybe you've given them a bit of extra time to process the information. Perhaps you've taken them to a quieter area. Sometimes something as simple as putting the curtains around to reduce distractions is another way, just to evidence that we've done what we can to make it as easy as possible for the patient. The next new question is, what concerns have brought about the need for a mental capacity assessment? So under the MCA, a person must be assumed to have capacity unless it is established that they lack capacity. We do not need to assess a patient's mental capacity unless there is reasonable belief that the patient may lack capacity, and we should, under this question, document what gave rise to the assessment of capacity. I've put down some more examples, so things like perhaps the family have highlighted that the patient is more confused than normal. Patient may be repeating themselves on the ward, unable to state their date of birth. They might be refusing essential treatments. That could give rise to a capacity assessment, or just behaving erratically. So these questions should look familiar. The 4 questions of the functional assessment have remained the same. The only difference is that we encourage you to provide details for either a yes or a no to each question. We have removed the failed at previous step option, as I explained before, and the functional assessment is now considered before the diagnostic, which will come next. So the diagnostic element asks, is there an impairment or disturbance in the functioning of the patient's mind or brain? And is that impairment temporary or permanent? So the only time we would answer no to this question is if the reason for the inability to make the decision is external. So it could be due to coercion or undue influence from external sources. We need to evidence that the reason for which the patient is unable to make the decision is due to an impairment or disturbance in the functioning of the mind or brain. It can be, but does not need to be, a specific diagnosis. It can be something as simple as confusion. We don't always have a diagnosis, but what this question is really asking is it an internal reason that that patient cannot make the decision, or are there external factors at play? So if we have reason to believe that the patient's impairment or disturbance is temporary, we should consider if the decision can wait to a time when the person may be able to make the decision for themselves. A lot of the time in an acute hospital, we don't have time, and that's practical and realistic. But if it is a decision that can wait, and the patient may well come out of a delirium in that period of time, then it should wait. So the statement of capacity is also remained the same. We would expect you to input based on all of the information and evidence on a balance of probabilities that the person has or lacks capacity to consent to the specific decision. For someone to be deemed to have capacity, we need to evidence that they can do all 4 aspects of the functional assessment. And for someone to be deemed to lack capacity, we need to evidence that they are unable to do at least one of the 4 aspects of the functional assessment, and that this is because of an impairment or disturbance in their mind or brain. So we move on to the best interest section. This is new. If your statement of capacity states that the patient has capacity to consent to the decision, the assessment stops here. It can be saved as it is. If your statement of capacity states that the patient lacks capacity to consent to the decision, then extra questions will appear below. These questions are asking you to consider the best interests decision. So the first few questions are, is there a registered lasting power of attorney, court-appointed deputy, or advanced decision to refuse treatment? If the patient is deemed to lack capacity and there is an LPOA or a court-appointed deputy for health and welfare, they should be consulted in regards to that decision, and they have the legal authority to make that decision on the patient's behalf. If the patient has made an advanced decision to refuse treatment, which is relevant to the decision under the Mental Capacity Act, then this should also be followed. It is essential that we have seen evidence of these documents and they're scanned into the patient's notes before any decisions are made. You can choose the option of I don't know, as this is often the case. It is the responsibility of the lasting power of attorney or the court-appointed deputy to make themselves known, and it is reasonable and appropriate to follow best interest decision making if we don't know. So the next question is there a relevant person who can be consulted regarding patients' past and present views and wishes? So we need to ensure that in establishing what is in the patient's best interests, we have spoken to someone who knows the patient well and can represent their views in an unbiased way. So this can't be anyone who is paid to provide care or support for the patient. If the patient has no person who is able to advocate on their behalf in decisions about serious medical treatment or long-term accommodation changes, then an independent mental capacity advocate, or an IMCA, should be provided. If the decision is to remain in hospital or to have less serious medical treatment, then we would not get an IMCA involved. Power have been commissioned to provide the IMCA service in Cambridgeshire. If the person is a patient in Addenbrooke's, Power will provide the IMCA service regardless of where the person normally resides. This might be new to you because we've recently changed from a service called Voiceability. The contract has changed to a service called Power. All the information is on our Connect IMCA page. You can search on Connect of how to refer, or you can get in contact with us at the Adult Safeguarding team and we can support that referral. So the next questions are, what are the patient's past, present wishes and feelings? We need to evidence as part of the best interest decision that we've considered the patient's wishes, feelings, beliefs and values, both past and present, usually by speaking to friends or family who know them and understand that information about them. And finally, please give details of any person you've consulted. So we have a responsibility to consult others in the process of establishing best interest decisions. And in order to evidence this, please just include the details of who you've spoken to. So, final question is, in consideration of all relevant factors in relation to the specific decision stated above, what is in the patient's best interests? This is a free text option and it's in relation to the specific decision, what is the best interest decision. So if the decision was for a patient to have an NG tube fitted, the best interest decision would be either yes, we feel it is the best interest of the patient for the NG tube to be fitted, or no, we feel it is not appropriate for the patient to have an NG tube fitted. So under this Section 4 of the Mental Capacity Act, there are 6 areas detailed of what to take into consideration when you're making a best interest decision. And this is sort of what's rounded the questions in the best interest section. These are to do not discriminate, consider all relevant circumstances, consider if it's likely the person will regain capacity, encourage participation from the person, consider the person's past and present views, wishes, values and beliefs, and consult relevant people. If we followed those 6 steps, we have the job of establishing a best interest decision. So food for thought. The Mental Capacity Act is a law. If you work with people of 16 and over, you have a legal duty to have regard to the Mental Capacity Act. If you do not feel confident completing a mental capacity assessment, it is your responsibility to discuss this with your senior and book on one of our monthly training sessions. The Mental Capacity Act, or Mental Capacity Assessment, is a legal assessment. Whilst professionals who specialise in cognition are often very capable of assessing capacity, the Mental Capacity Assessment should be completed by the person who is most relevant to the decision. The only time a patient's mental capacity needs to be reassessed is when you have reasonable belief that their capacity has changed, or grounds to reassess their capacity. Best interests is an essential part of assessing mental capacity. If you have questions or concerns about mental capacity, please do contact the Adult Safeguarding team. And there are our contact details. So we have Tracy Brown, who is the Adult Safeguarding Lead, Smadar Outhwaite, who's the Adult Safeguarding Specialist Nurse, and myself, who's the Mental Capacity Act and Deprivation of Liberties Practitioner. I've also included the general Adult Safeguarding email address, which we all have access to. And there's also a frequently asked question page on Connect. So by all means, have a look there if it's out of hours and you can't get hold of anyone. You may find your answers there. Thank you very much for listening. Take care.